Yes, my lord. My lord, I want to mention item number 7.
Clear, don't you? Yes.
No objection. I'm for respondent 5 and 6. I pray for 2 weeks time, my lord.
Why?
Because my senior has some personal difficulties, my lord.
I think this matter has
Heard, Your
been
Lordship.
heard in part.
Heard.
Have you concluded your argument?
Your Lordship, we have completed, Your Lordship. The petitioners, we have completed, Your Lordship. We are waiting for their side.
Only for their response.
Yes, Your Lordship.
Your first state.
Yes, Your Lordship.
Miss, then a counsel for the respondent number
5 and 6.
5 and 6 has sought for accommodation on the ground that the learned conducting counsel is indisposed. Miss Learned Counsel appearing for the petitioner has no objection to the same. Accordingly, prayers allowed. This is matter up to 2 weeks.
Supplementary list, item number 1.
You are ready with the hearing?
Yes, my lord.
We'll take it up after at the end of the board.
And of the board, my lord. It may not take much time, my lord. It may not take much time, my lord.
What is your?
15 minutes from my side at the most, my lord. Or at the end of the board also, fine.
End of the board is fine, my lord.
Fine.
Since we'll be hearing the
Yes.
matter will be heard on merits.
Yes, my lord. End of the board, my lord.
Lordship.
We'll see how it goes.
My lord.
From daily list, item number 1.
May it please, Lordship. Lordship, the issue in this revision petition is whether there can be a second execution. Now, a suit was filed, decreed. They had filed a suit, it was decreed for eviction. Now, without issuing notice to the tenant, the execution was carried out. But CPC contemplates that in a suit for eviction, if there is a decree, then notice has to go to the tenant to vacate the premises or to remove the properties, which was not done in the instant case. The execution went ahead. In fact, there are 2 parts to the execution. One is the money part, where we have to pay the area rent, and the other is for for possession. Now, my lord, the trial court, what it did, it went ahead with the execution without issuing notice. The decree holder took possession of the suit premises, took possession of all the belongings, and it is recorded also that the execution is complete in respect of possession. Now, my lord, after 6 or 7 years now, they filed another application before the executing court saying that for direction to us to take the properties, to take back the properties. Honor, I'll just draw your lordship's attention to the relevant portion.
To take back what?
The properties which belongs to me inside the premises after the execution. So the question here, my lord, in this revision petition is whether a second execution is permissible or not under the law. Your lordship will come to page 19. This is the notice to the bailiff. Bailiff of the court. Whereas the undermentioned property in the occupancy of the judgment debtor has been decreed to the plaintiff in the suit, you are hereby directed to put the said decree holder in possession of the same and remove all obstructions, and you are hereby authorized to remove any person bound by the decree who may refuse to vacate the same, and if found on the lock, to break the lock and open the door. You are further commanded to return this warrant on or before the 21st day of September with an endorsement certifying the day on which and the manner in which it has been executed or why it has not been executed. So this was the order of the court to the bailiff without issuing notice to the judgment debtor. Now, before going further, what does this law contemplate? Your Lordship will come to Order 21. Rule 35 and 36. Twenty-one 35.
Yes.
Decree for immovable property. Where a decree is for the delivery of any immovable property, possession thereof shall be delivered to the party to whom it has been adjudged, or to such person as he may appoint to receive delivery on his behalf, and if necessary, by removing any person bound by the decree who refuses to vacate the property. Where a decree is for the joint possession of immovable property, such possession shall be delivered by affixing a copy of the warrant in some conspicuous place on the property, and proclaiming by beat of drum or other customary mode at some convenient place the substance of the decree. Where possession of any building or enclosure is to be delivered, and the person in possession, being bound by the decree, does not afford free access, the court through its officers may, after giving reasonable warning and facility to any woman not appearing in public according to the customs of the country, to withdraw, remove or open any lock or bolt, or break open any door, or any other act necessary for putting the decree holder in possession. Now 36. Decree for delivery of any immovable property when in occupancy of the tenant. Where a decree is for the delivery of any immovable property in the occupancy of a tenant or other person entitled to occupy the same, and not bound by the decree to relinquish such occupancy, the court shall order delivery to be made by affixing a copy of the warrant in some conspicuous place on the property, and proclaiming to the occupant by beat of drum or other customary mode at some convenient place the substance of the decree in regard to property. Now, what does these two rules contemplate? Well, at first, you must give notice. It is only if the judgment debtor refuses to vacate, then the question of directing the bailiff to even use force will come into play.
Any period specified?
My Lord, I'll just, before we go further,
What is the period of notice?
no period has been specified, but first, before you go to the extreme step of breaking the lock, you have to give notice. That is what the law contemplates. And my Lord, we'll just come to page 30. Well, my Lord, I think in this case the records will be necessary.
Let us hear the.
My Lord, we'll come to page 30. This is the typed copy of the order dated 21/9/2017. Decree holder represented by counsel seen the report submitted by the bailiff with regard to execution in respect of the suit premises. As per the report, the execution of the suit premises was conducted by the bailiff of the court along with the process server on 30/8/2017 in the presence of the decree holder and inventory list prepared of all items lying in the suit premises. During the execution, the judgment debtor also came along with the counsel, but after some time left the suit premises. An undertaking was also signed by the decree holder that all items, materials seized will be under his custody, and further undertakes to hand over all seized items, materials to the judgment debtor whenever he comes and claims them. The seized items, materials described in the inventory are kept inside the suit premises, which the same has been locked and sealed. The bailiff has also submitted a report of handing over possession of the ground floor of Solansar mansion situated at Jail Road to the decree holder, along with the keys of the said room, shop premises. Seen and peruse also the inventory list along with so-and-so. Part decree. With regard to eviction of the judgment debtor from the suit premises by way of recovery of possession is satisfied. So what the trial court has said, execution in regard to monetary portion left. So my submission, my lord, is that the court, once the decree has been satisfied, it becomes functus officio. It cannot pass any further orders.
So you mean that a decree cannot be divided into 2, 3, or 4 parts?
No, it can. Now here's a decree which is in 2 parts. One is in respect of possession. As per the court, possession is complete. Now, in respect of the money portion, what we have to pay, that is remaining. In fact, that is still pending. That is still pending. Now, my lord, the decree was executed in my absence without issuing notices to me. I don't know what exactly happened there. In fact,
you are a judgment data.
yes.
But here it says you were also present.
No, we in fact, I will come to that, my lord. In fact, after we saw that the shop had been broken open, it is not that we got a notice from the court. We did not receive any notice. We went there and immediately we filed an FIR. Because we don't know, some of our properties may be missing. A lot of their vehicles, I think there are 7 vehicles, and there are files, there are many things there. Now, what I'm trying to say, my lord, now they have taken advantage of the decree by getting it executed behind my back. Now they come again before the court. Now, they don't know what to do. Everything is in their possession, decree has been executed, and file another petition for removal of those properties from the suit premises.
Who has filed? You?
No, they have filed.
Yeah, fine.
So, our contention before the trial court is that this court has become functus officio. It cannot pass any other order in respect of the decree in this, with regards to possession.
See, Mr. Dingro,
Yes.
there's a portion here which says an undertaking has also been signed by the degree holder
Decree holder.
that all the items, materials seized will be under his custody, and further undertakes to hand over all the seized item materials to the judgment data.
Yes.
So, this is the undertaking given.
That's the undertaking
As and when you are ready to collect them, you are free to
given by them. Given by them. Undertaking is given by them to the court.
Exactly. You cannot say. You cannot say that you have been prevented from assessing your materials, items, whatever.
Definitely, my lord, we have been
Also to be to take possession of the same, because here is very clear. As and when you are willing or ready to take, you can repossess them.
That is true, my lord. That is true. But what they have done, they have gone again to court. My lord, what has happened? There was another, in fact, by mistake, we did not annex the copy of the order. There was another proceeding before this court in a revision petition. And their stand in that revision petition is that the decree has been executed, it is complete, and the revision is not maintainable. What I'm trying to say is that their stand is that the decree has already been satisfied.
Fine. So this is the impugned order.
No, the impugned order, my lord, will come to page 72. Lord, I'll just come to it's a long order. The submission, my lord, come
What
to
is the
page
substance of this?
76.
Yes.
peruse the order dated 76, 7. Will come from 6, my lord. That at this stage, the decree holder is not pressing on the execution of the decree with regards to the monetary portion, but only praying before the court to pass necessary orders directing the judgment debtor to remove all the goods and articles from the suit premises in the presence of the bailiff of the court and police supervision. That's again asking for another execution of a decree. Peruse order dated 21/9/2017 and 24/4/2018, and also the bailiff report along with the inventory report undertaking by the decree holder, handing over the vacant possession, or order dated 30/8/2017, and on perusal of the same, this court has observed that the judgment debtor along with his counsel was present at the time of execution in the said premises but left after some time. Hence, this court is not inclined to accept the submission made by the learned counsel for the judgment debtor that the execution proceedings dated was done without notice to the judgment debtor and behind his back. It is a prayer of the learned counsel for the judgment debtor that during the execution proceeding, some of the valuable properties of the judgment debtor went missing, and thus he has filed an FIR with regards to the same. This court has also perused order dated 9/4/2024 in transfer petition number 2 of 2024, passed by the Honorable High Court of Meghalaya, wherein this criminal revision number 2 of 2024, which was pending in the Learned District and Session Judge Shillong, has been transferred to the Court of the Learned District and Session Judge Nongport. This court has also perused the order dated 9/11/2023, passed in criminal revision number 12 of 2022 by the Honorable High Court of Meghalaya, and has observed that the same has been dismissed as withdrawn. On perusal of both the mentioned orders, this court is of the view that the matters pending before the Learned District Session Judge Nongport pertaining to the FIR filed by the judgment debtor has no relevancy to the execution proceedings pending in this court. It is also observed that in both the orders, the Honorable High Court of Meghalaya, there is no mention whatsoever about the execution proceeding pending in this court. In consideration of the observation made above, this court is inclined to direct the judgment debtor to remove all the goods and materials from the suit premises in the presence of the bailiff of this court and OC Sardar PS on or before 10/5/2024. Bailiff to unlock the suit premises in the presence of judgment debtor, decree holder and OC Sardar PS. So, my lord, what the trial court is essentially doing is to execute the decree again. Now, it is on record that the possession has been handed over to them. Vacant possession has been handed over to them. They have taken possession, undertaking. Now, what the trial court is trying to do is again execute the decree, which in my submission is not permissible. And I have various decisions, even of the Supreme Court, which says that second execution cannot be permitted. My lord, the various orders.
How many respondents are there?
There's only one.
Sole respondent.
Sole
And the
respondent.
plaintiff before the trial court.
Yes.
So you will accept notice?
It's for final hearing, Lords.
Admission hearing.
It's for admission hearing. This has been pending for some time. May be disposed of. I can offer my reply tomorrow. My learned senior may complete today. It's a short point, Lords.
Since Mr. Dingdo said the
Records would be required.
Won't be necessary, my Lords. I'll satisfy Lordships. Records will not be necessary. Now, the thing is that before the trial court, the monetary part of the decree is being executed as we speak. The matter is being fixed on a regular basis. Bringing the records would mean that that monetary decree, the execution thereof, will be stalled. That is the objective of the petition. My Lords will hear it. If there's any necessity to call for the records, I'll oblige, my Lords. But I'll satisfy, my Lords, that on the face of it's a point of law, it does not require perusal of the records. There are certain orders. I have the entire list of the orders. I'll take your Lordships through it. It won't be necessary. My Lords may hear me tomorrow. If your Lordships are still unsatisfied, may call for the records. I have no difficulty with
Well,
it.
what I can suggest is that I'll make a I'll make copies of all those orders. We have copies, my lord. Instead of calling for the records.
Lordship, exactly.
I will-
I also have the records. So we can assist, my lords, with
We
the
can
records.
assess, it'll be easier. Because, my lord, they are around.
So what happened is, see, since this is listed today for admission hearing,
Yes.
so this petition, this application will be admitted and matter to be posted for hearing, final hearing, and on that day, parties are.
May I pray the lordships will take it up next week then for final hearing?
Can we fix it on 28th?
28th, my lord.
Lordship, 20th is fine.
No? 27?
Make a
20,
Yes, fine.
oh, 27.
27th is fine.
27.
Tuesday.
Heard Mr. E.T. Dengro, Learned Senior Counsel. Who has pressed for admission of this petition, this application 227,
2 to 7.
Yes.
2 to 7.
preferred under Article 227 of the Constitution. Next, the Learned Senior Counsel has submitted that the petitioner is essentially aggrieved by an order dated 18/4/2024 passed by the Learned Assistant District Judge in Miss C. I have to pick to page 72. Talk with Tony Joe. Para 6 and 7 of the said order has been pointed out to say that the court, the trial court, having issued a decree and execution of the same being duly ordered in course of time, another execution order was passed on the self-same degree, which is impermissible in law. Being thus aggrieved, the petitioner has approached this court for adjudication of the matter. Mr. S.N., Learned Counsel, has accepted notice on behalf of the respondent and has no objection to the admission of this petition. He, however, prays that this matter may be finally heard and disposed of on the next day, as agreed to by the parties. Accordingly, on consideration of the submission made, without going to details of the merits of this petition, this court is prima facie satisfied that the petition is fit to be admitted. The same is accordingly admitted. On consent by the parties, this is matter for hearing on 27.
Highly obliged, my lord.
Item number 2.
Please, Your Lordship. My lord, in this matter we've received instructions. Unfortunately, it appears there is
Yes, please.
But in this matter, I was supposed to take instructions to ascertain whether an award had actually been drawn up. It appears there is no award, unfortunately, my lords. So I'll just take instructions. Lordships may have it next week, whether to start afresh. Lordships may give a time-bound direction. I'll just take proper instructions.
Your Lordship,
So the process of acquisition has been carried out.
That I believe has already
carried
been
out,
done.
but there's no award. That's exactly our
Lordships,
case.
there's no formal award. And apparently there was a inquiry which was to be undertaken with regard to certain claims and counterclaims of title. That is also still pending.
That would be prevalent under Section 30.
Lordship, 13 of the
That
new.
would come.
My lord, but
This is the old act, isn't it?
No.
No.
Now,
Now it will be apparently under the new act.
New Act 24 says, my lord, if there is no award, pass within a period of 1 year, then the new Act will come into play, even if the acquisition was under the old Act.
Lordship. So the determination of the compensation will be under the new act. So I'll just examine that. Lordships may have it next week.
Yes, because you see, if you decide to take necessary steps at your end, so they will be satisfied.
Yes, that's what
Absolutely.
that's our prayer also.
As far as the award is concerned,
Yes, my lord.
whatever the case may be, you see, if there's a objection to the same, that comes under a different
Yes.
proceedings.
Lordship, correct.
Mr. S. that he has fairly submitted that on being instructed, it appears that the award, as far as the acquisition proceedings are concerned, involving the parties herein, have not been given. It's not given. It has not been determined, isn't it?
The expression uses published, my lord.
Not been published.
Published.
Has not been published. Has not been determined and published. This being the case, it is the submission of the learned G that some time may be allowed for specific instructions to be received in this regard. How long?
A week, my lord. A week's time.
Accordingly, as prayed for. Place this matter to 1 week.
Highly blessed, my lord.
Item number 3.
My lord, on behalf of respondent number 6, we have filed our counter yesterday.
I've received a copy, Lordship. Lordship, the matter may be fixed for hearing. Will not file any
Lordship,
rejoinder.
I may pray, Your Lordship, the affidavit filed by the maybe
We'll give a copy.
copy. We'll also share our copy with them, Your Lordship.
But there is no system where you will file a rejoinder to his.
No, I'm not saying that, Your Lordship. I would like to see what is the stand of the district council, because our stand is very clear, Your Lordship.
If I'm not mistaken, Mr. Shulai,
Lordship.
I think that Sora case is a case where a rejoinder was filed to a counter.
Yes.
No, I'm not saying
just
to
saying
file a
that,
counter,
see,
Your
I'm
Lordship.
just recollecting. Maybe
Lordship.
this is the case where you would go into that aspect of the matter. Mr. T. Tindo, Senior Counsel. And your special counsel or standing counsel?
Special counsel.
And special counsel for the respondent KHADC has submitted that the counter affidavit on behalf of such respondent has been filed for this court.
After 2 weeks. Okay.
Mr. M.L. Lumpio, learned counsel for the petitioner, has also submitted that the same has been duly furnished to the petitioner. No rejoinder would be filed by the petitioner in this regard. It is prayed that the matter may now be posted for hearing. Accordingly, on prayer made,
After 2 weeks, Your Lordship.
This is matter for hearing after 2 weeks.
Apply, Your Lordship.
Item number 4.
Well, these matters were heard. Hearing has been concluded, my lord. I have filed my synopsis, my lord, both the cases. So my submission, my lord.
I'm praying for another 2 days time. It is ready, my lord. My lord may fix it on Monday. By Monday, my lord will be filing.
If I can pay on, they can always file it with the court master, my lord. Every time it is listed for last, we
My
will
lord,
have
the
to.
other matter needs to be heard, my lord. The only we are
Both the
filing
cases I have filed.
Other matter means what?
means the
There are two.
2 cases, my lord.
Both has been heard.
162, my lord. It is not heard, my lord.
They are tagged together, isn't it?
They are tagged together, but this is a separate matter, my lord. This matter needs to be heard.
That cannot be. See, once matters are tagged together, it would be presumed that maybe a common order has to
My
be
lord,
passed.
all the 4 matters were connected, tagged together, my lord. But my lord has heard the matters separately, my lord. The first 2 matters were disposed of separately, and this one is heard, my lord. And the last one needs to be heard, my lord.
And they should have been, given separate numbers so that one matter can be disposed of, the next can be,
Well, I have no problem if,
lord,
but
fix it
both
on
the
Monday.
cases, I have filed the hearing. But only thing, my lord, if it is Monday, I have no problem. But then it should be taken on
My lord, my lord.
issues are
same.
My lord, there is the facts are different, my lord.
facts may be different, but if essentially the core issue is the same,
Same.
then the court may not have to go into the exercise of preparing separate orders. A joint common order may be
Yes,
passed.
lordship can pass comment.
Facts will just be it will differ here and
My
there.
lord, no, fix it on Monday. We'll clarify whatever.
So, if it is for hearing on Monday, my lord, only thing, my lord, let her ensure, my
No,
lord,
we'll do
is
it on Tuesday then
My lord.
for hearing,
for hearing.
my lord. Only one matter.
No, that the other matters you said.
Yes, the
this
last
is
matter, my lord. WPC 162 of what?
162.
My lord.
But so far I am concerned, my lord, both the cases I have filed my synopsis. Both I have
But you
filed.
have not been heard.
I don't know. But if they make a hearing, then I'll have to be here,
How,
my lord.
Mr. Sen, how can you?
Lordship.
If they are saying that they have not been heard in the other matter, which means that I have not also heard you. You are the respondent,
I'm responding.
so you are only filing your written argument on what basis?
No, if it is to be heard, my lord, let it be heard, my lord. How long, my lord? Now it is almost, I think, 6 years, my lord. 6 years.
10 years.
15 matter. I think this is the oldest matter in the High Court, I think.
Not the oldest.
10 years.
But anyway, it's one of the oldest, so it shouldn't be,
My lord, fix it on Tuesday, my lord.
Tuesday,
My lord.
no adjournment.
My lord.
Well, make it clear, my lord.
You are present or not,
Yes.
matter will be heard. So, Ms. Datta, you prepare yourself.
My lord.
Come. Ms. Datta, Learned Counsel for the Petitioner, has submitted that there are two similar matters tagged together, of which one of them has been heard, and direction for filing of written argument has been issued by this court. However, the other matter, that is WPC number 162 of 2015, has not yet been heard. It is prayed that the other matter may also be heard, so as to enable this court to take up the common issues in both the cases, and to consider the Mr. S. N. Standing Counsel for the respondent Nehu has no objection to the prayer made. Accordingly, on consent by the parties, this matter is the related matter is to be heard on the next date fix. It is made clear that no adjournment will be allowed as far as hearing of the matter on that day is concerned. List this matter on 27th.
Item number 5.
So, Mr. Paul,
Balance.
matter is ready for hearing.
Balance. Are you sure? Can start.
Can we do one thing? Because the other matter, was a passover. The other matter was a passover matter. So I'll take up the other one, and then this one.
Balance, or if it is convenient, we can have a date fixed when this matter can be taken up.
I have some other part matter.
You suggested it.
Any date convenient, Balance, next week? Subject to my lord's convenience, of
Can you
course.
see what I do? So we'll take it up on 28th.
29?
Next Thursday.
Next Thursday.
Yeah, Thursday.
Or would it be convenient, my lords, if we have it on the 27th or Tuesday?
27, I think we have 1 or 2 matters listed for here. Or that previous case, that Nehu case also.
Or we can keep it on the 3rd.
Third or fourth, madam.
3rd of June.
Third or fourth, June.
8th of June. We can see how we do it.
Nice.
After it. Second.
Second, Monday.
6 minutes. 6 minutes. Next matter. On consent by parties, matter is now posted for hearing on
First, we have to overcome that.
No, but that I've satisfied.
second
Forgotten about it.
2nd June. Mr. Kriya?
Item number 6.
Also. Well, it's in item number 6. This is a matter where a revision has been filed before the Honorable Court against an order of conviction. Well, it's a
Excuse me.
My lord,
Private
may-
respondents.
union is also there, my lord. The union, yes, the Union of India, my lord. So
You are ready?
they are not a formal party, my lord, because all the money, compensation, everything comes from the union, my lord. The state is only.
With this state, the relief is sought against the state. For the purposes of the present writ petition, all relief is sought against us, not against the union. So union has declined to file any affidavit in this matter. So matter may be heard, my lord.
Yes. So, my lord,
This is not a. Okay, you
my
start.
lord, here is I have filed this writ petition, my lord. Today it's only on the maintainability of this writ petition because the state has filed an application challenging the maintainability of this writ petition. Now the ground
we are here on the issue of
of maintainability, my lord. Now the main ground of the challenge on the maintainability is that this issue has been already settled by the then Guwahati High Court. Before coming to the facts of the case, my lord. So that is the only ground, my lord. And my ground and my stand is that, of course, Guwahati High Court has passed certain orders, but subsequent event has led to a new course of action, my lord. So now on the last occasions, my lord, not before my lord, or not before the other the bench, my lord, we heard at length, and a question was put to me, my lord, and probably that goes to the very core of the issue at hand also. So the issue was the question that has fallen from his lordship was, can once the issue is settled by the judicial order, can subsequent executive orders can revive? My lord, the answer would be no. It cannot. Any executive order cannot supplant the judicial order, my lord. But my lord, in this case, on the facts and circumstances of the case, my lord. But my lord, there is the answer would be, if to give an answer in one word, my lord, it would be no, my lord. But there is also a but. What is that but is if there is the exemptions, exceptions to that also, my lord. Now, what is that exceptions to that, my lord? This is what I would like to address, my lord. And if my case fit under that exemptions or not, my lord. So, my lord,
exception as to the overriding power of the executive order vis-a-vis the judicial order.
No, my lord, not overriding, my lord, because, my lord, we cannot. We by any amount of judicial order, my lord, it cannot reverse the judicial ruling, my lord. But what it can be done, my lord, what it can be done is to extend benevolence to that order, my lord, or it can on equity, my lord, and also on policy driven relief, my lord. So here, my lord, having said, so these are the exemptions. If I fall under these exemptions, then it will not amount to overruling the order, but however, putting or adding benevolence to that order, my lord. Supplementing the judicial order, but not supplanting the judicial order, my lord. That is the exemptions, my lord. Here, my lord, what happened was, just now, my lord, having said that, my lord, I would like to take to page 17, that is the facts of the case also will be there, my lord. Page 17. Page 17, my lord has got. This is the order of the Guwahati High Court, then the Guwahati High Court, Shillong bench, my lord. Page 17, my lord.
Just a moment. Yes.
paragraph 2, my lord. May I just read paragraph 2, my lord? And before that, my lord, I like to apprise my lord, page 13, my lord. Page 13, 1-3, page 13, my lord. Page 13.
Yes.
My lord has got that WPC number 315 SH of 2002.
Yes.
The parties are Balpakram Aking Nokma Social Welfare Association. So this is the party before my lord today. So now we'll go back to 17, my lord. Page 17, paragraph number 2, my lord. May I just read, my lord? It's a short order. In WPC number 315 SH of 2002, the petitioner is an association of Nokmas of the Aking lands situated in South Garo Hills, Meghalaya, and is registered under the Society Registrations Act of 1860. White registration certificate number so and so. In the year 1985-86, the state government, for the purpose of setting up Balpakram National Park, proposed to acquire the said Aking lands in several phases. In the first phase, 10 Aking lands with an estimate area of 220 square kilometers were acquired at the cost of rupees 3.63 crores at the rate of rupees 1.65 lakhs per square kilometer. Again, in the year 91-92, another area of Aking land estimated to be 76.25 square kilometer was acquired at a cost of rupees 1.26 crore at the rate of 1.65 lakhs per square kilometer. Thereafter, in the year 1994, an additional Aking land of 15.5 square kilometer was acquired at a cost of rupees 25.69 lakhs and was handed over to the Forest Department on 19/4/1994. Again, in the following year, in the year 1995, another Aking land measuring 39.91 square kilometer was acquired at a rate of 65.85 lakhs at the rate of rupees 1.65 lakh per square kilometer. In this manner, a total of 352 square kilometer have been acquired till 95-96. However, in the year 1996, an additional Aking land measuring 114.85 square kilometer was sought to be acquired from the Aking lands, from the 8 Akings for the purpose of expansion of the park. In the case of the petitioner that except for this 114.85 kilometer of land, no proper land acquisition proceedings were initiated apart from issuing notifications purportedly under sections 4 and 6 of the Land Acquisition Act of 1894, and that the unsuspecting illiterate Nokmas were made to sign on blank papers which were made out to be agreements. They were never informed of the right to receive money under protest or of their entitlement to higher compensation in the absence of adequate compensation. However, according to the petitioner, in assessing the rate of compensation, the respondents totally ignored the rate fixed by Garo Hills Autonomous District Council and paid them rupees 1.65 lakhs per square kilometer, which worked out to be a mere 200 per biga, while determining the quantum of compensation. The value of standing trees, crops, mineral deposits, etc. were not taken into consideration. Solatium was also not paid, ignoring the provisions of the Act. Next, my lord. Now, from own pleadings of the petitioner, it becomes obvious that the landowners represented by it are aggrieved by the quantum of compensation awarded to them between 1991-92 and 95-96. In my opinion, it is now too late in a day to challenge the award made some 7 to 15 years before. Moreover, if the petitioner is really aggrieved by the quantum of compensation so awarded, it had remedy under section 18 of the Act for reference by the collector to the Land Acquisition Court, provided that it was filed within the period of limitation prescribed thereunder. Having not done so, the writ petitioner, insofar as 352 square kilometer is concerned, is barred by non-exhaustion of an alternative statutory remedy. As for So the other part, my lord, is not been 114 is not been acquired. So it may not be required to go to that part, my lord. Though, so the grievance end here. So no, my lord, the issue of 352 square kilometers, my lord, has been, the issue has been disposed of by on a technical ground for non-exhaustion of the statutory provisions. That's the only thing now. Now, thereafter, my lord, what we do, but the ground reality, my lord, whether it was adequately paid, it was not paid, my lord, that issue remained, my lord, and this is an undisputed fact. The only remedy that we were been thrown out of court is because we did not exhaust our statutory remedy. Now, my lord, does that bar me from filing a representation to the government? In my humble submission, it does not bar me, my lord. So accordingly, my lord, I have filed my representations, my lord. I filed my representations. My representations are at page 23, my lord.
Yes.
Page 23, my lord. This is addressed to the Secretary of the Chief Minister, my lord. And the subject is humble request to look into the matter in respect of Aking land acquired by the government of Meghalaya for Balpakram National Park. The relevant will be, my lord, page 25, my lord. Page 25, para 4 onwards, my lord. Page 25, my lord. May I just read this paragraph, my lord?
Yes.
That's the secretary of our association through RTI has been able to obtain some copies of agreement and undertaking given by the members of the NOCMAS to the Forest Department Wildlife Wing, Meghalaya, Shillong, on different dates. It is stated that as per information accumulated from NOCMAS, that NOCMAS were asked to sign on blank papers and other type papers, but it was not been explained to the members of the NOCMAS before obtaining signature and undertaking given by the NOCMAS and their family members to the Forest Department's Wildlife Wing, Meghalaya, and in the agreement it is detected, notice that the department paid compensation to NOCMAS of Rongsu Agal, Aking 50% out of the total amount of compensation, and Nadongkol Aking land paid full amount of compensation, and the remaining NOCMAS were not paid till now due to the doubt in the survey and resurvey conducted by the Geological Survey of India, and could not proceed further for payment of the compensation and kept in abeyance, and hence they are yet to get the payment of compensation, and we have never been informed of our right to receive our money under protest or our entitlement of higher compensation in absence of adequate compensation. Rather, we were asked to sign on blank papers, which was later purported to be an agreement taking undue advantage of our ignorance and simplicity. In the process, compensation as per market rate was deprived to us. So, my lord, here, my lord, this is a post judgment. This is a post judgment. What we say the post judgment, my lord? We came to know through RTI, and the survey, the survey conducted by the Survey of India does not match with the taking over of the land of the some of the Akings. Some were 50% paid, whereas some were 100% paid. The villages were not explained. These are all post. These are new facts which has been developed after the judgment of the Guwahati High Court, my lord. And my lord, also can see at page 35, my lord. Page 35. This is another representation, my lord. Oh, I'm sorry. This is page 35, my lord. 2-3 representations are there. I'm not bothering, my lord, with those representations. Now I am going to the response of the government, my lord, page 35. The type copy is on the following page, my lord. After page 35, the type copy is, it's not been paged here, but there's a following page is a type copy, my lord. That is dated 21st December 2011.
Yes.
21st December 2011. And this is from the Secretary, Law Department, my lord, to the special officer on special duty of the Forest and Environment Department, my lord. Subject: acquisition of land for extension of Balpakram National Park and matter relating to the representation of the President, Secretary of Balpakram Aking Nokma Social Welfare Association. Number 1. In inviting a reference to your letter on the subject above, I am directed to say that as appeared from the papers, this is a case in which the land acquisition in 1985 to 86 appears not to tally with the land actually taken possession by the government of Meghalaya for extension of Balpakram National Park, which comprises of a large area, and as such, the poor and illiterate landowners are not in the position to verify regarding the measurement of the land. It appears from the papers that an area of 352 square kilometer was taken and that no enough compensation was paid to the effect on the land acquisition assessment should normally be of the land, and the standing trees and crops appears to be not in this case. Hence, it is also that the rate of compensation was paid which appear not to be according to Section 23 of the Land Acquisition Act of 1894, and not as per the market value of the land, and also as per record maintained by Garo Hills Autonomous District Council on the date of publication. According to the judgment of the Honorable Guwahati High Court, the matter is to be referred and decided by the District Collector and the Special Judge Civil Court. With regard to the letter so and so, August, the points raised by the Chief Wildlife Warden in Meghalaya, Shillong is to be determined by the Collector and also by the court, and it should be placed before the Collector and the court for the decision. As such, it may not be proper for the department to offer views before the decision of the Collector or the court. Legally, the provision of the land acquisition does not found place in limitation 1963. However, limitation under Section 18 of the Land Acquisition Act has to be seen in the light of Dikman Sangma versus State of Meghalaya AR 1994 Guwahati 26, which means whether they have made such application to the authority or not. In the circumstances above, the matter is to be decided by the District Collector and a Special Judicial Officer under Land Acquisition Act, or through civil court, or as the case may be by mutual settlement. Advocate General was also consulted. So on the basis of the Advocate General's consultations, my lord, and based on our representation who are before my lord, this order was passed, and here very clearly two things came out. Number one, there is also uncertainty about which land they are talking about. Of course, they said 352 square kilometers are taken, money has been paid, but on ground, there is still a dispute. This is one thing. Second thing is, my lord, what they're saying is, this has to be decided by the District Collector. This has to be decided by the District Collector. So let it go to the District Collector. So these are all post judgments, my lord. Now, my lord, page 36. Page 36 is a very important document, my lord, which favors me. Page 36, my lord. This is a letter of the Deputy Commissioner. This is a letter of the Deputy Commissioner, my lord. I will just take my lord's this thing to read this. My lord has got page 36.
Yes.
My lord, this comes from the Deputy Commissioner, South Garo Hills. My lord, now the Deputy Commissioner under the Land Acquisition Act also, he is the authorized person to assess, to reassess, my lord.
Yes.
So he writes to the Undersecretary to the Government of Meghalaya, Revenue and Disasters Management Department of land acquisition in respect of BNP and a matter relating to representation by the President and Secretary of the Balpakram Aking Nokma Welfare Association. That's me, my lord. So, in response to your above letter directing me to take action according to law in the matter, I have the honor to state that I have made an in-depth examination as to whether a reference to civil code can be made at this stage. In this regard, I have gone through civil rule number so-and-so decided by the Justice Dhiren Barua of Guwahati High Court, reported so-and-so. This is a case in which the government of Meghalaya had acquired 5,803 bighas of Aking land, paid rupees 100 and 200 per bigha to the landowners as compensation. The landowners had not accepted the award under protest. They approached the Honorable High Court for a reference under Section 18 of the Land Acquisition Act. The High Court took the view that they are illiterate villagers and it cannot be expected that those villagers should act in the manner the Act provides. It will be too much to expect that the Honorable Judge directed the Deputy Commissioner William Nagar to refer the case to civil court, and this was the decision of our own Honorable High Court. To my knowledge, till date, the ruling has not been overruled yet. Hence, it is felt that we are bound by this ruling. A photocopy of the same. Number 2. A single bench decision of Punjab and Haryana High Court disposed of on 21st/05/2004 Faridabad Gas Power Project Limited versus Narendra Kumar and others. This decision also reiterated that principle laid down in the Guwahati decision cited above. In para 9 of the judgment, it states, there is another aspect of the matter. It is undisputed fact that landowners are illiterate villagers. It is well settled law that a person against whom waiver is to be placed must be aware of his existing legal right. In the present case, the rustic villagers whose lands were being acquired cannot be expected to be aware of their legal right under the Act of LLA. It was the duty of the authorities to tell the landowners in unambiguous terms that they had a right to accept the compensation under protest and claim enhancement thereof. Thereafter, in para 12 of the said judgment, it is observed in no uncertain terms that in such a situation, the landowners who are rustic villagers and had accepted the compensation without raising protest in writing cannot be said to have waived their right to seek reference under Section 18 of the Act. The said rationale laid down in this decision is applicable with greater force to the Balpakram Nokmas, who are at the time of acquisition of the land in question were residents of the most backward tract of Meghalaya, having a very poor percentage of literacy rate, less educational facilities, suffering from total lack of surface transportation, etc. AIR 1988 Himachal Pradesh, page so-and-so, LA Act. Petitioner are rustic villagers making application seek a reference to court under section a rejection on a ground that application was not maintainable since petitioner received compensation without protest, not justified. Before the bar placed by the second proviso, the subsection 2 of section 31 can be invoked against any person. It must be shown by acceptable evidences. Number 1, that he was aware of his right to make an application for reference under section 80, that he knew also that such right would be defeated if he accepted the compensation without protest. So, my lord, all these Gyan Singhs and all these things all favoring me. Then finally, page 39, my lord, the finding. What is the finding of the Deputy Commissioner, my lord? Giving my considered thought to the entire matter, I find, number 1, the case of Balpakram accusations are more than 27-28 years old. The illiterate people were paid only 1.50 lakh per square kilometer, which abysmally low by any standards. Due procedure prescribed in LA Act for acquisition of land was not followed, resulting in great economic loss to the rustic Nogmas. The government of Meghalaya, wedded to the concept of tribal welfare, is perhaps duty bound to mete out economic justice to the aggrieved Nogmas, especially reference to the civil code will merely consume a lot of time and so on and so. In view of that, I felt inclined to make a reassessment of the land with reference to the value per viga of the existence so and so at the relevant my action finds legal so and so. So thereafter now these are post judgment developments, my lord. Now the deputy commissioner himself admits, and he is a person who has got authority under the Land Acquisition Act. He himself says that the amount that we paid to the rustic villagers by any standard is low, number one thing. And he he admits that land acquisition proceeding was not followed in letter and spirit, my lord. Two things comes out. And third thing, he talks about some equity and equity, my lord, and a policy driven relief for the rustic villagers, my lord. So therefore, my lord, if the government wants to oppose me at this point of time, my lord, about the res judicata, my lord, it is not not a question of res judicata, my lord. It's a question of systemic deprivation to the rustic normas. Even after 30 years, my lord, they have been asked to run from pillar to post. And their own officers admits on the face of the record that yes, we have done injustice. Now, if they have done injustice, why are they not acting on it? Why are they constraining me to file a writ in the court, my lord, to be objected by their own government, saying that, sorry, you are barred by res judicata. So, my humble submissions, my lord, for the purpose of this maintainability, my lord may kindly consider the facts on the records, my lord, and direct them to file the affidavit in oppositions, my lord.
What is the response to this letter?
To this letter, my lord? No, thereafter, my lord, there was he has carried out.
Carried out the...
yes, he has carried out, subject to this thing, he has carried out the assessment, my lord. That is how he, but I...
Where is that?
My lord, my lord, would be the following pages, my lord, page 40 onwards, my lord. But I will confirm, my lord, this is page 40 onwards, my lord. Page 40, 41, 42, 42, my lord. This is subject to some clarifications, my lord. I'll clarify this one, my lord.
No, but how can see?
So what he said, my lord, here is thereafter, my lord, to my instructions, my lord, there is no correspondence thereafter to this, my lord. In fact, we have written certain letters, my lord. Prayer for Jesus. After this, my lord, we have written by our page 49, my lord. By our page 49. By our page 49, my lord.
Yes.
We have requested for reassessment based on the reassessment, my lord. And And my lord, I'm just breaking the link little bit, my lord. So after this letter, we have filed application for reassessment, my lord. Now this reassessment was not carried out. Therefore, we came to this honorable court again, my lord. And that there's an order, direction passed by this honorable court, that is at page. Where was that page? To dispose of our representation, my lord.
Page 63.
Page 63 maybe. Oh, my lord, I'm grateful to my lord. Yes, my lord. So we're just leaking this thing. So my lord, thereafter, this honorable court had directed my lord to dispose of our representations, and my lord, the government thereafter dispose of our representation. The impugned representation is at page 65, my lord. Page 65. Page 65.
Page 65?
My lord, page 65. Page 64, and then page 65 is the order, my lord.
Yes.
So by this, the representations were disposed of, rejecting our request for reassessment, my lord. So therefore, my lord, now my prayer. So we have prayed for quashing of this order, my lord, this impugned order, and also to act on
that plea of rejection.
Yes, my lord. Yes. So, my lord, now, my lord, therefore, my lord, these are all post-judgment development, and this has not, as I repeat, my lord, did not supplant, my lord. However, my lord, this is to supplement because the fact of the matter remains, my lord, is that the NOCMAs, my lord, have been paid, as admitted, my lord, have been abysmally paid very low, my lord. Land acquisition proceeding was not carried out in accordance with law, my lord. So therefore, my lord, my writ petition, my lord, finds maintainability, is maintainable, my lord, with a new course of action. This course of action, my lord, and cannot be dismissed at the threshold in this. Let the government file affidavit in oppositions, my lord. So that is all, my lord.
Please, Your Lordship. We have challenged the maintainability of the writ petition primarily on the ground that the entire grievance of the petitioners stood settled and disposed of by the Honorable Guwahati High Court. And my friend's references to different representations and whatever reports or interdepartmental communications that are present in this writ petition do not furnish him a fresh cause of action. My lords, we'll first come to the judgment of the Guwahati High Court at page 13. My friend has referred to it, but I'll just show your lordships the same judgment in a different perspective.
Yes.
Because their perception of what has been written in this judgment is a little different, is at variance with what we understand. What my lords will find, at the very first page, there is a reference of the cause title of various writ petitions.
Yes.
Please see the first one. As far as the present writ petition is concerned, their writ petition was numbered WPC number 315 SH of 2002.
Yes.
Then my lords will see there is WPC 75 SH of 2001. Then similarly, the next page, there is at page 14, my lords, is Civil Rule number 152 SH of 1997. Then Civil Rule number 153 SH of 1997, Civil Rule number 154 SH of 1997, and so on. So in total, there were 5 writ petitions which were disposed of by a common judgment. Please have page 16, my lord.
Yes.
So the date of the judgment is 2nd of March 2011, and this is what it reads. This batch of writ petitions arising out of the alleged taking over of Aking lands for the purpose of Balpakram National Park in the Garo Hills Autonomous District Council, with the consent of the councils appearing for all the parties, are taken up together for hearing and are being disposed of today by a common judgment. Now, as far as the determination of the first writ petition, which is the petitioner's writ petition, is, that is WPC 315 SH of 2002, my friend has already read it, that is contained at para 2 onwards, and that stands concluded at para 3. So the dispute was their allegation that they were not paid sufficient compensation for acquisition of an area measuring 352 square kilometers.
Yes.
Now, what the Honorable Court has held is that due to non-exhaustion of the alternative remedy under Section 18 of the Land Acquisition Act, they are not entitled to any relief. And the claim here was that they have not been paid sufficient compensation and they should be paid enhanced compensation. In any event, the writ court cannot go into that issue. That's a fact-finding issue. And because of the nature of the act, which is a self-contained act, all remedies with regard to enhancement of compensation have to be done by the competent authority under Section 18. So this is where it stood concluded. Thereafter, I'll just take your lordships a little ahead in the judgment. Please have page 22. Here towards the end, the learned court was considering and deliberating upon the other writ petitions which were clubbed together. Please have page 6, para 6.
Yes.
There is a certain observation that is made here. Coming now to Civil Rule number 153 SH of 1997 and Civil Rule number 154 SH of 1997, the facts in these cases are virtually similar to the foregoing Civil Rule number 152 SH of 1997. Therefore, if and when an application for reference under Section 18 of the Act is filed by the petitioners, jointly or severally, the same will be considered by the collector along the lines indicated above, order accordingly. So this order directing some of the petitioners to file the application under Section 18 of the Land Acquisition Act was only confined to these writ petitions, my lord, not to the petitioner's writ petition. Now this has been confused by the writ petitioners, and it has been projected that this particular direction was also applicable to them. Because thereafter, after disposal of this matter, they did not prefer any writ appeal. This order had attained finality. Thereafter, what they did, they preferred a representation before the Chief Minister. Please see that at page 23. Addressed to the Private Secretary to the Chief Minister.
Yes.
This is one representation, my lord. Then please see at page 27, there's another representation. Page 27.
Yes.
This is again addressed to the Honorable Chief Minister, dated 3/12/2012.
Yes.
And this is a little significant because the petitioners are under a misunderstanding of this particular judgment of the Honorable Guwahati High Court. If your lordships have page 27, this is a representation addressed by the petitioners to the Honorable Chief Minister, dated 3/2/2012.
Yes.
Now please turn to the next page, my lord, page 28.
Yes.
Page 28, para 8. Thereafter, till date, we have been fighting for reprisal of the entire matter with the government and also in the High Court at Guwahati and Shillong. We prayed for making a reference to civil court in terms of Section 18 of the LA Act. The Law Department, after a thorough perusal of the matter, has recommended a reference to the civil court. Then please turn to page 30. Lordships will find there is yet another representation which is addressed to the Honorable Chief Minister.
Yes. Yes.
All praying for reassessment of their land acquired. And all of them are based on a particular letter which is addressed by the Secretary of the Law Department to the Officer on Special Duty, which is at page 35, my lord. Please have, my friend has just read it. I'll just take your lordships to that same letter again. The typed copy is in the page right after page 35. If your lordships have it, I'll just read out the first paragraph. This is relevant. In inviting a reference to your letter on the subject above, I am directed to say that as appeared from the papers, this is the case in which the land acquired from 85-86 appears to not tally with the land actually taken possession by the government of Meghalaya for extension of Balpakram National Park. Balpakram National Park, which comprises of a large area, and as such the poor and illiterate landowners are not in the position to verify regarding the measurement of the land. It appears from the papers that an area of 352 square kilometers was taken and that no enough compensation was paid to the effect on the land acquisition assessment should normally be on the land, and the standing trees and crops lost appear to be not in this case. Hence, it is also the rate that the rate of compensation was paid which appear not to be according to Section 23 of the Land Acquisition Act 1894 and not as per the market value of land, and also as per the record maintained by the Garo Hills Autonomous District Council on the date of publication. Now, please see this particular line. According to the judgment of the Honorable Guwahati High Court, this is the judgment that I just referred to, my lord.
Yes.
The matter is to be referred and decided by the district collector and the special judge, civil court. So the entire basis of these interdepartmental communications is based on that last paragraph, which related to other writ petitions. And this is a misunderstanding on their part. On the basis of this, they proceeded to understand that the Honorable Guwahati High Court had directed for a reconsideration of the matter. And which is why the law department proceeds on this incorrect basis, my lord. And then kindly see the next page. The last sentence, fourth line from the bottom, my lord. In the circumstances above, the matter is to be decided by the district collector and special judicial officer under Land Acquisition Act or through civil court, or as the case may be by mutual settlement. Advocate General was also consulted. So they were all proceeding on a wrong premise that the Honorable Guwahati High Court had directed them to proceed under Section 18 of the matter. That limited direction related to a completely different writ petition, my lord.
What is the contents of those particular writ petition?
That writ petition, my lord.
Yes,
I'll just take your lordships back to the writ petition, the order that, please see page 16, 16. I apologize, my lords, page 17, 17.
Not 17, just let's go to the operative portion.
Well, there are different writ petitions.
No, I've just
Yes, my lord.
the specific reference where you say this civil rule number 153.
Yes, my lord. That's page 22.
And 154.
Yes, my lord. Civil rule number 153, 1997, civil rule number 154, 97. The facts of this case are virtually similar to the foregoing civil rule number 152 SH of 97.
Okay.
Therefore, if and when the application
so what is contained in 152?
These are different batch of writ petitions, my lord.
True, but
They're again asking for reassessment, but again not related to the same properties.
Exactly.
These are completely different
That's what
properties. Yes, my lord. So the facts are similar as far as these three writ petitions are concerned.
I see. Since we don't have the the copy of this petition here,
My lord.
We don't know.
No, I'll take your lordships. Please see page 21, para 5. It has been discussed in para 5. My lords have it.
Okay.
In civil rule number 152 SH of 97, the 5 Aking lands belonging to 5 petitioners were proposed to be acquired by the government of Meghalaya for extension. For extension, my lord.
This is
Not
for
for the original acquisition. For extension of Balpakram National Park in the year 1985-86, it is alleged by the petitioners that the forest officials, after initial measurement of the lands, obtained their signatures on some blank papers which were made out to be agreements for parting with the respective lands for a consideration of rupees 1.5 lakhs per square kilometer. Their variable lands were thereby expropriated by the payment of nominal sums in the name of compensation. The grievance of the petitioners is that the value of Nokma Aking land in 79 was 1000 per bigha, and the total value of the lands so taken over should have been 7,48,000 at this rate, but the forest department proposed to pay rupees 1.5 lakhs per square kilometer. It is also contended that the usual norms which have always been followed in a land acquisition proceeding were completely given a go by in this case. Be that as it may, the petitioners in para 6 of the writ petition revealed that compensation at the rate of 1.50 lakhs per square kilometer was calculated, and paid to the Nokmas, but in the same breath, they contend that the area of land acquired in 85-86 is now being questioned. In my opinion, the conclusion is inescapable from the averments of the petitioners that they have been awarded the compensation at the rate far below the rate fixed by the district council and for a smaller land than actually acquired by the state respondents. If that is so, they ought to have approached the collector to refer the disputes raised by them under Section 18 of the Land Acquisition Act, so and so, for a decision of a land acquisition court. However, having not exhausted an alternative remedy provided for the land acquisition under so and so, the writ petition is not maintainable. The petitioners are, however, directed to file an application under Section 18 of the Land Acquisition Act for referring the disputes to the Land Acquisition Court, if permissible by law. The collector will examine it as to whether such application will be time barred or not, and thereafter take a decision in accordance with law. Order accordingly. Coming now to Civil Rule number 153 SH of 97 and Civil Rule number 154 SH of 97, the facts in these cases are virtually similar to the foregoing Civil Rule number 152 SH of 97. Therefore, if and when an application for reference under Section 18 of the Act is filed by the petitioners, jointly or severally, the same will be considered by the collector along the lines indicated above. Order accordingly. So this particular order, permitting them to file an application under Section 18, was only confined to these three civil rules, not with regard to the petitioner's writ petition. There, the court had already foreclosed their opportunity to file the application under Section 18. Now, they misunderstood this particular direction in Section 6 to be applicable to them as well. And the same misunderstanding also occurred with the state. And not entirely the state, one of the officers of the state, that is the Secretary of the Law Department, who then proceeded to make this interdepartmental communication, which I was just referring to, Willard, at right after page 35.
Yes.
So it's on the basis of this then if your lordships will have, there is another communication at page 36. Page 36 minute. This is a letter dated 17th of August 2012 issued by the Deputy Commissioner of South Garo Hills to the Under Secretary Revenue and Disaster Management, Shillong. The relevant portion is at page 39.
Yes.
The second last paragraph. This reads, in view of the above, I felt inclined to make a reassessment of the land acquired with reference to the value of per bigha of land that existed as per District Council's valuation at the relevant period. Now, there is no provision under the Land Acquisition Act permitting the DC to conduct a reassessment.
Who is to direct?
He does not have the power.
No, who is to direct him?
If at all the courts, if at all, it could be, and I'm not admitting this, perhaps in a reference proceeding, if it is absolutely necessary, maybe there is a power, I'm not really sure, but unilaterally, suo motu, the DC does not have the power under the Land Acquisition Act. Simply because he has conducted a reassessment and he has referred his findings to somebody higher up in the department through an interdepartmental communication does not furnish a fresh cause of action to the petitioner. And the petitioner cannot say that a new legal right has been created in his favor. So I just read this part, Lord. In view of the above, I felt inclined to make a reassessment of the land acquired with reference to the value of per bigha of land that existed as per District Council's valuation. And once I'll digress for a moment and just come to the issue. His entire basis of conducting the reassessment is by looking at the rates which have been fixed by the District Council. The division bench of this High Court has already held that the District Council does not have the power or authorization to fix rates for land acquisition. And this is still holding the field. This has not been challenged or set aside. So his entire premise that the reassessment has been conducted on the basis of the District Council's valuation itself goes. Then he goes on to say, my actions find ample legal support in a division bench decision of our own High Court in Winkle Star's case, reported in GLT so-and-so. Now please see, this is important, my lord. In the above premises, I place before the court, before the government, who may perhaps be pleased to consider my above views. This by no stretch is an order, my lord. It's merely his views and he's admitting that. My views / steps favorably and distribute fair and speedy economic justice to the aggrieved Nokmas. Again, my lords, I'm stressing, number one, it is not an order. It is not addressed to the petitioners. He does not have authorization, and most importantly, this is merely his views. And on the basis of this, he submits his views to somebody higher up in the department. So this is therefore an interdepartmental communication, nothing more than that.
And he went ahead and reassessed the land.
He went ahead and reassessed the land without anybody asking him to do so.
So this is the...
And he's basing everything on the district council's valuation, which our own High Court has held in 2016 is not valid. It's completely without sanction of law. And then, my lord, the petitioners continue to write representations to the Honorable Chief Minister, and then eventually they approach this Honorable Court by way of a writ petition, my lord. Please see page 57, WPC 500 of 2018.
Yes.
Now let's have it. So this is a writ petition that the present petitioner filed before this Honorable Court, numbered WPC 500 of 2018. Please have page 60, my lords. I'm just referring to one of the averments made in this writ petition at page 60, para 6. May I read, my lord?
Yes.
That being aggrieved, the Nokmas had approached the then Guwahati High Court Shillong bench by way of writ petition WPC number 315 of 2002, and the same was disposed by judgment dated 2/3/2011, giving liberty to file application for reference under section 18 of the Act before the concerned collector. This, my lords, is the basis on which they've come before the court. This is absolutely misconceived. There is no such order operating in their favor, directing them to file a section 18 application. And even if there was, let's assume for a moment that this particular direction was extended to the petitioners. Where is the application under section 18? Up until 2018, no such application under section 18 was ever filed by them before the concerned court or before the collector. Then please see the next page, which is the prayer, my lord, page 61. This reads, in the premises aforesaid, it is therefore prayed that your lordships may be graciously pleased to admit the petition, call for the records, issue rule calling upon the respondents to show cause as to why a writ in the nature of mandamus should not be issued, directing the respondents to make payment of compensations as per report of the respondent number 4 dated 17/8/2012 to the petitioner Nokmas, and or may pass such further orders as your lordships may deem fit and proper. This is with regard to the collector's suo motu reappraisal of the matter, which I was pointing out is completely illegal. So they ask for a mandamus directing the respondent to pay compensation based on his report. Now what happens to this particular writ petition? It is disposed of by an order at page 63. Let's have it. Order dated 11/2/2019.
That was referred to by the...
Yes, my lord. This reads, heard learned court for the learned counsel for the petitioner so-and-so, who submits that the petitioner has filed a representation dated 22nd May 2017 addressed to the respondent number 4 and prayed that the respondent number 4 may be directed to dispose of the representations. Respondents number 3 and 4 are hereby directed to dispose of the representation by speaking order within 3 weeks. Now please see, they abandoned their relief with regard to issuance of mandamus for payment of compensation as per the TC's report, which was dated 17/8/2012. So effectively, explanation 5 of section 11 res judicata applies here. They have themselves not sought that relief, and that relief was virtually denied. Then, my lords, their representation is disposed of by a letter which is at page 64 the forwarding letter is at page 64, dated 4th March 2019, and the speaking order follows at page 65 and 66 onwards. My lord has it?
Yes.
Please see page 66,
Yes.
the second last paragraph.
Page.
Page 66,
Yes.
the second last paragraph.
Yes.
In para 3 of the same judgment, this is the judgment of the Honorable Guwahati High Court.
Yes.
The judge observed that it is now too late in the day to challenge the award made some 7 to 15 years before. Moreover, if the petitioner has really aggrieved with the quantum of compensation so ordered, it had the remedy under section 18 of the Act for reference by the collector to the Land Acquisition Court, provided that it was filed within the period of limitation prescribed thereunder. Having not done so, the writ petitioner, insofar as 352 square kilometers are concerned, is barred by non-exhaustion of an alternative statutory remedy. Considering the whole gamut of the petitions filed by the Balpakram Aking Nokma's social welfare organization, I find that the petitioner cannot agitate any more to challenge the quantum of compensation paid to them, as they have executed the agreement with the Forest Department, accepting the rate of compensation of rupees 1,50,000 per square kilometer, inclusive of all costs prior to payment of compensation, which are matter of record. The remedy available to them under section 18 of the LA Act, which has now been replaced by the new Act so and so, which also has a similar provision like section 18 of the old Land Acquisition Act in section 64, cannot now be relied upon by the petitioner due to time bar. The time limit provided for reference to the Land Acquisition Court in section 18 of the Act is maximum 6 months, while section 64 of the new Act provides a period of 1 year if the collector is satisfied that there was sufficient cause for not filing it within the period specified. As has already been observed by the Honorable Guwahati High Court, Shillong Bench, it is now too late in the day to challenge the award made some 7 to 15 years before. I do not find any section of law under which the petition of the Balpakram Aking Nokma Social Welfare Association can be entertained in the present circumstances. Having accepted the quantum of compensation in full without protest, they cannot at the same time challenge it after a lapse of several years. Hence, the petition for enhancement of the compensation filed with the petitioners is found to be baseless and not maintainable. So, by a very well considered and reasoned order, their representations are dismissed. Now, they have come back by way of this writ petition, and kindly see the prayer here, my lord. It's at page 7 of the writ petition.
Yes.
If your lordships have it. In the premises aforesaid, it is therefore prayed that your lordships may be graciously pleased to admit the petition, call for the records, issue rule calling upon the respondents to show cause as to why a writ in the nature of mandamus should not be issued, directing the respondents to make payment of compensation as per the report of the respondent number 4 dated 17/8/2012. So this is a replication of the prayer contained in the previous writ petition. Now, so as I had said, my first ground of objection was that this case is barred by res judicata on 2 grounds. One, that the original judgment of the Honorable Guwahati High Court had already settled the matter. They cannot re-agitate it by saying that there is a new cause of action. This cause of action is not new at all. Please have section 10, my lord. Section 11 of the CPC.
Mr. Sen.
My lord.
Mr. Yovin.
My lord.
See, it appears that the merits of the case has been.
Yes, exactly.
The merit of the case
Because there's a maintainability only, my lord.
See, you're talking about maintainability.
Yes, yes, my lord.
But from what has been observed, from your submission as well as Mr. Sen,
my lord,
you have touched on all the merits of the.
That is the reason why from day one I've been insisting direct for filing an affidavit in opposition, because these are all merits of the cases.
From his submission, it may not be required to file an affidavit also.
My lord.
It may not be required to file your counter.
My lord. My lord.
See, what the court would do on the basis of your submission,
my lord,
would finally dispose of the petition.
My lord. I'm just submitting my synopsis of the argument, my lord. Of course,
because the sum and substance of the
the
case has been understood.
Yes, my lord. Yes.
Except if if you resort to laws of pleadings.
No, nothing more. I'll just place some reliance on a few judgments.
To say that you would require to file a formal counter affidavit.
Not necessary, and I'll also say why. From 2018, when this writ petition was filed, none of the courts have ever insisted that we file our formal affidavit in opposition. Even the courts are of the view that this writ petition is not maintainable. May I just refer to one particular order, my lords, of 14/10/2019.
You see, the fact is,
Lord.
this, as far as maintainability is concerned,
My lord.
I would say that his case is maintainable,
My lord.
in as much as you see, confining the issue only to the reply to their representation,
Lordship.
for which they are aggrieved.
Lordship.
So we go into all that, the same, story of arbitrariness, illegality, and all those, so on and so forth, which would be very much, enable this court to, to go for a judicial review.
Yes, my lord.
Okay, so we would accept that. This court would accept that.
My lord.
The next part would be going to the merits
Yes.
of the case, which you have make a submission in detail, as I have said. So finally, if the parties agrees to,
My lord may
matter can be
dispose of, my
can
lord.
be disposed of.
But then, my lord, that
On merits.
on merits, and then they have waived their right to they have waived
No, I'm not saying
their
they
right
waived
to
at
file
any
their
point,
affidavit,
but
because they're saying that they don't want to file an affidavit because it's not maintainable.
That's what I was asking, Mr.
Yes, my lord.
No, but it's fixed for that affidavit itself. I have filed an affidavit questioning maintainability. Lordships will decide that. Now, my friend is insisting that I should file an affidavit. That has been his modus operandi right from the start. Right from the start. I don't know why they're insisting that we should file something. On the basis of the writ petition itself, he has not disclosed the right. There has to be a clear right to sue. There is nothing.
No, but
I'll take another 5 minutes, my lord.
Yeah.
I won't take
Let-
any longer. Just 5 minutes to show your lordships that this case is not maintainable. I'll please reliance with just 4 judgments, my lord. So if your lordships will kindly have explanation 5 to section 11.
Yes.
My lord. Explanation 5 to section 11, my lords.
Yes.
Any relief claimed in the plaint which is not expressly granted by the decree shall for the purposes of this section be deemed to have been refused.
Yes.
So at the very initial stage, when they were before the Honorable Guwahati High Court, they had again made a prayer for enhancement that was rejected. So therefore it is barred by res judicata. That judgment operates as a judgment passed in a former proceedings and is binding. Number 2, in the second writ petition, when they came before this Honorable Court under section WPC 500 of 2018, their prayer was that they should be paid enhancement as per the report of the DC. That prayer was not granted. So therefore, by virtue of explanation 5, which says that in case a particular relief sought for is not granted, it will again operate as res judicata. Well, a question may arise as to whether the doctrine of res judicata would be applicable to writ proceedings. So I'm referring to one judgment. 2019 13 SCC 42. Mellows will have page 52. The second last page, minute.
Para
Para 8.11.
8.11.
Hello.
Yes.
Let's me read it. The decision in so and so was not challenged before the Supreme Court and has since attained finality. Therefore, the relief sought by the appellants before the High Court was barred by the principles of res judicata. Reference can be made to the decision of the Constitution Bench in so and so's case, wherein, on behalf of the 5-judge bench, it was held as under. It is well established that the principles of res judicata are applicable to writ petitions. And just please see the next page, Milord. It's an extract of the same judgment, Placitum C.
Okay.
There's a part which is itemized. The binding character of judgments of courts of competent jurisdiction is in essence a part of the rule of law on which the administration of justice, so much emphasized by the Constitution, is found, and a judgment of the High Court under Article 226 passed after a hearing on the merits must bind the parties till set aside in appeal as provided by the Constitution and cannot be permitted to be circumvented by a petition under Article 32. Well, the second is a very important judgment where my friend is basing his entire case and claiming that a fresh cause of action has accrued in his favor by virtue of those interdepartmental communications that were made by the DC to his higher-ups. So this is 2023 10 SCC 807. The relevant page is at page 813. My lords have it. Page 813, para 15.
Yes.
It is well settled that interdepartmental communications are in the process of consideration for appropriate decision and cannot be relied upon as a basis to claim any right. The court examined the said question in a judgment reported in so-and-so. Reliance was placed on so-and-so's case to hold that merely writing something on the file does not amount to an order. Then please see para 17 at page 815. This reads, this court and so-and-so held that a noting recorded in the file is merely a noting simpliciter and nothing more. It merely represents expression of an opinion by the particular individual. It was held as under, this court in a judgment in so-and-so held that a noting recorded in the file is merely a noting simpliciter and nothing more. It merely represents expression of opinion by the particular individual. By no stretch of imagination, such noting can be treated as a decision of the government. It was held as under. A noting recorded in a file is merely a noting simpliciter and nothing more. It merely represents expression of opinion by the particular individual. By no stretch of imagination, such noting can be treated as a decision of the government. Even if the competent authority records its opinion on the file on the merits of the matter under consideration, the same cannot be termed as a decision of the government unless it is sanctified and acted upon by issuing an order in accordance with Articles 77, Articles 166. The noting in the file or even a decision gets culminated into an order affecting the rights of the parties only when it is expressed in the name of the President or the Governor, as the case may be, and authenticated in the manner provided in Article 77 or Article 166. A noting or even a decision recorded in the file can always be reviewed, reversed, overruled, or overturned, and the court cannot take cognizance of the earlier noting or decision for exercise of the power of judicial review. So this is precisely the case here. An opinion was only formed at a very nascent stage, and it was referred to the higher-ups of the government for consideration. Subsequently, on the basis of their representation, that was reversed and modified, and that became final. Now, what the petition is asking for is we should go back to that original report which was sent by the DC only for the consideration of the government, and they claim that a new right has been created in their favor. On the basis of this settled law, my lords, they have no right at all on the basis of some opinion that was formulated by the DC. Then there's another judgment, lords. This is 2022 SCC Online SC 249. This is, my lords, on the issue of what is the fate of successive representations that are filed.
Yes.
Please have page 2, para 5.
Yes.
Para 5 minutes. As observed by this court in a category of decisions, mere representation does not extend the period of limitation, and the aggrieved person has to approach the court expeditiously and within a reasonable time. If it is found that the writ petitioner is guilty of delay in laches, the Honourable Court should dismiss it at the threshold and ought not to dispose of the writ petition by relegating the writ petitioner to file a representation and or directing the authority to decide the representation once it is found that the original writ petitioner is guilty of delay in laches. Such order shall not give any opportunity to the petitioner thereafter to contend that the rejection of the representation subsequently has given a fresh cause of action. That's again the same case here. They have successively filed representations after representations. Then they came before this Honorable Court by way of Writ Petition 500 of 2018, abandoned their relief, principal relief, and asked only for disposal of the representation. Now, once the representation has been rejected, they say a fresh cause of action has now been formulated in their favor. So this does not give rise to any legal right in favor of the petitioner, my lord. And lastly, this is again in great detail, this judgment has been rendered, my lord. 2019 15 SCC 633, again on the issue of representations and what would be the fate. Does filing of successive representations renew the cause of action? Lord, I'm referring to page 640 para 16. Lordships have it?
Yes.
Page 640, para 16. This court had occasion to consider the question of cause of action in reference to grievances pertaining to service matters. This court and so had occasion to consider the case where an employee was terminated and after decades he filed a representation which was decided. After decision of the representations, he filed an OA in the tribunal which was entertained and order was passed. In the above context, in para 9, the following has been held. The court's tribunals proceed on the assumption that every citizen deserves a reply to his representation. Secondly, they assume that a mere direction to consider and dispose of the representation does not involve any decision on rights and obligations of the parties. Little do they realize the consequences of such a direction to consider. If the representation is considered and accepted, the ex-employee gets a relief which he would not have got on account of the long delay. All the reasons of the direction to consider. If the representation is considered and rejected, the ex-employee files an application writ petition not with reference to the original cause of action of 82, but by treating the rejection of the representation given in 2000 as the cause of action. A prayer is made for quashing the rejection of representations and for grant of relief claimed in the representation. The tribunal's high courts routinely entertain such applications petitions ignoring the huge delay preceding the representation and proceed to examine the claim on merits and grant relief. In this manner, the bar of limitation or laches gets obliterated or ignored. This court again in so-and-so case on belated representations laid down following, which is extracted below. When a belated representation in regard to a stale or dead issue dispute is considered and decided, in compliance with the direction of the court tribunal to do so, the date of such decision cannot be considered as furnishing a fresh cause of action for reviving the dead issue or time-barred dispute. The issue of limitation or delay and laches should be considered with reference to the original cause of action and not with reference to the date on which an order is passed in compliance with a court's direction. Neither a court's direction to consider a representation issued without examining the merits nor a decision given in compliance with such direction shall extend the limitation or erase the delay and laches. So I would conclude by saying, my lords, by examining the entire case, lordships will have to look at their cause of action as it existed in 2001 when they had filed the writ petition and the grounds on which that writ petition came to be dismissed. Lordships will see from the various representations and also the entire basis of the interdepartmental communications will find that there was a complete miscomprehension of the judgment rendered by the then Guwahati High Court, which is why this case or the grievances have travelled this far. This is a clear case of miscomprehension of the judgment of the Honorable Guwahati High Court. This case has no legs to stand. It has to be dismissed because the entire matter has already been decided and concluded by the then Guwahati High Court. Obliged.
My lord, I'm submitting my notes of argument, my lord, synopsis of the argument. And my lord, just half a minute to reply, my lord. All these citations that has been cited, my lord, has to be looked into the facts of the case, my lord. Facts of each case. Why I say so? Because here, my lord, here is a group of Nokmas, a group of villagers who has contributed their big land for the development of forest, my lord. And it's a property. It's a property of the nation, my lord. This is a public interest where you have where the Nokmas have decided to part away, my lord. Part away. That's for the nation interest, my lord. Therefore, all these judgment has to be read, has to look the background on what premises this was passed, my lord. And also, my lord, in 2021, my lord, the Guwahati High Court dismissed the writ primarily for non-exhaustion, my lord, of remedies under section 18 of the Land Acquisition Act, my lord. Deputy Commissioner, rightly or wrongly, my lord, in 2012, my lord, what he admits illegality, he admits illiteracy, he admits failure to follow acquisition procedure. Therefore, he suggests reassessment or reference to the court, my lord. He has suggested reassessment or reference to the court after admitting all this, my lord. Therefore, my lord, these have my lord, this revives the issue, my lord, but by not questioning, revives the issue by not questioning the judgment, but by creating a new executive acknowledgement of injustice, my lord. So therefore, my lord, I have a new course of action. That is all. Thanks. Obliged.
Obliged.
You're filing you're giving a synopsis of an argument.
I'll have it prepared by end of day, my lord.
I have given.
May supplied by Monday, my lord. Or by tomorrow. I'll have it done by tomorrow, my lord.
Heard learned counsel for the parties. I heard Mr. Yogin learned counsel for the petitioner. And Mr. SN learned G for the respondent number. State respondent number 1 to 4.
1 to 4.
Respondent number 5 has chosen not to participate in the hearing on the ground that no specific relief has been made out against them, against the union. Mr. Yuben has also filed the written synopsis of his argument, to which Mr. Sen has prayed that he may be allowed to file his written synopsis in a day or two. Accordingly, this matter is reserved for judgment.
Highly obliged, my lord.